Good evening, everyone. It is my pleasure to welcome you to another of Mercantile Barristers webinar series, specifically dedicated to our construction clients, is specifically on the subject of adjudications. You are welcome. By way of introduction, if you have not joined any of our webinars prior, my name is Mr. Samuel Okoronkwo. I'm a specialist construction barrister and I'm head of chambers at Mercantile Barristers. As you may be aware, this is a construction adjudication webinar series part 4. We have historically dealt with parts 1, 2, and 3 prior to getting on to part 4. Part 1 dealt with the strategy of adjudications and big picture. Part 2 dealt with adjudication notices, timing and preparation. And part 3 dealt with referrals and responses. Whilst part 4 will be dealing with the adjudication decision. So without further ado, let us make progress. And perhaps I should have added that prior to becoming a specialist construction barrister, I spent, I would say, at least 16 years as a quantity surveyor and project manager dealing with substantial construction projects. So I have first-hand industry knowledge as well as legal knowledge of the matters that I'm going to be speaking to you about. In today's session, we are addressing how adjudicators actually approach dispute resolutions, what will make an adjudicator trust one side to the dispute resolution over the other, the common mistakes that destroy otherwise good claims, the practical realities behind adjudication outcomes, and what happens after the decision is issued. Those, if you like, in a nutshell, are the key things that we'll be covering this evening. So without much ado, let's get into it. Now, the commercial reality, well, construction disputes are rarely won by emotions, and this is important to appreciate this point. Disputes are generally won like any other disputes in the construction industry. It is not different. It is the power of evidence. Evidence is the key to everything. You cannot make assertions without being able to back it up. And if you're going to come to dispute resolution, you should be able to get your ducks in a row, arrange your evidence before you start. And you should ensure that your evidence is in fact credible. So the credibility of what you present is key. You are just as credible as your evidence. If your evidence isn't credible, unfortunately, you're not going to get very far. Now, if you've participated in adjudications, you will appreciate the significance of timing. Time is of the essence. Speed is of the essence. So the timing of your notices, the records that you've kept with respect to the times, the issues that you're going to argue relate to, and of course, the preparation that you make. Now, all of this is prefixed to the foundation of solid contract administration. If your contract is being properly administered, in other words, you're maintaining adequate record keeping, then your likelihood of being successful in your dispute resolution will be much higher than if you were otherwise haphazard in your approach. So the strongest legal argument often fails if the project records are weak. Now, if the project records are good, it supports no end the quality of legal arguments that you can make, because it is a combination of the facts and the arguments that will then give you your winning proposition. Without those, you're unlikely to be successful. So what I'm taking is a bird's eye view. So you're taking a helicopter view, saying, which are the key elements that I have to pay attention to? Evidence, evidence, evidence. Nothing could serve your case better than evidence. Now, what adjudicators actually want from you in the course of trying to decide whether to make a decision in your favor or otherwise is that you have to start your case practically with telling a good story. Telling a good story, the key to presenting your case is a clear chronology of what is it that you say happened and when and how. So a clear chronology is invaluable. A coherent contractual proposition that you will set out in saying, this is the contractual position and this is what happened that displaced this contractual position in order to leave me in a position where I'm having to make this claim. Now, on the other side, if you're the responding party, you are going to keep a good eye on what chronology the claimant, the referring party has put forward, their coherent contractual position. And it will be your position to point out what inconsistencies that exist, in other words, to undermine what otherwise on the face of it looks like a solid case. Then you have to have your evidence, as I previously remarked. Your evidence has to be very well organized. You would have had to have served the proper notices and in due time. And when you come to valuation evidence, make them realistic. Do not exaggerate them for the sake of it. In other words, do not overclaim. Relate your valuation to the contractual rates to the extent that those contractual rates are replicable. You try and replicate them or prorate them as the case may be, but make sure that they are realistic. So you cannot have, say, for example, quoted at £20 per square meter in your contractual documents, and because you're in a claim position, you want to then claim at £30 per square meter. That would be unrealistic. There would be no justification. Of course, unless you are able to point to an element of actually doing the work, which you can say justifies the enhancement on the rates. So realistic valuation is of the essence, not an exaggerated one. Now, if you're going to advance any witness evidence in the course of your adjudication, then that witness evidence must be credible. It has to be factual, it has to be firmly formed, and it has to carry credibility with it. And simplicity is key. Do not overcomplicate for the sake of it. Now, the easier you make the decision, the more persuasive your case becomes. The easier you present your application, the easier you make your argument. Not that you don't deal with complexities, but you simplify for the benefit of the adjudicator so that he can grasp it. The more persuasive your case becomes, and easier it will be for him or her, the adjudicator, to appreciate it and be able to evaluate it. So if you make incoherent argument and your chronology is inconsistent and all over the show, for want of a better expression, and your evidence is not organized, then how can you realistically expect the adjudicator to be able to appreciate it, understand it, and be able to decide in your favor? So sit back before you advance your argument. Please think about the chronology. What is my storyline? What is my coherent contractual position? Have I organized my evidence in such a way that it is persuasive and it could be very easily understood? Have I served the appropriate notices? And there are myriad notices that one can be being obliged to issue in the course of an adjudication, depending on what the issue is that you're going to be addressing. Okay, now, what commonly wins when you are presenting your case? The strongest of cases often always include properly administered contracts. So if you are involved in any part of construction work, you would appreciate that a disagreement, a misunderstanding, a difference in opinion as to how long that piece of work should have taken you on site to execute, or indeed how much you're supposed to pay for it, is only around the corner. Now, considering that disagreement abound, you prepare yourself for it. You rarely do start on site without some kind of indication of how long it is going to take from start to finish. Now, if you are commencing a project without a contract duration being agreed, I cannot overemphasize that you're laying foundation for disputes. Even if it is not agreed, make sure, if you are the contractor, that you state what you believe the contract duration should be. Okay? Now, you have, when you're looking to win, to present your case, you have to ensure that you're properly administering your contract, so you know the contract duration, and therefore you have a construction program. You have clear payment intervals, valuation dates, and that if you are due a payment, that you're actually making a payment application and you're making it in due time. That generally you are maintaining good contemporaneous records, so that when something is changing, you do not want to record the change after the event. You want to record the change when it is happening. If you lack information, issue your request for information when you become aware that you're lacking that information. You may not appreciate it, but that request for information is a vital piece of evidence, vital piece of record as to when you're asking for the information. When you do, in fact, receive the information you seek, either by a drawing issue or an architect's instruction or contract administrator's instruction, you record when you receive it, ensure that it is dated. That, for example, is giving you an indication from the date that the information was sought to the date that it was received. It may well be that in your delay analysis, you will be able to demonstrate that that timeline in some way, shape, or form impacted the construction program. Now, that it will impact the construction program is not necessarily too much of a big issue, but if it impacts the critical part within the construction program, then it is sounding in overall delay in the construction contract. So you have to maintain good contemporaneous records. If there is a delay evidence, ensure that you have recorded it and that you have served the notices, because appreciate that in most standard forms of contracts, it is incumbent upon the contractor to serve a notice of delay when they become reasonably, when it becomes reasonably apparent to them that there will be a delay. Not only do you have to notify that a delay incident has taken place, you have to indicate what extent of delay that you believe that will occasion. Even if it were just an estimate, the fact that you have maintained that record and given served that notice will protect you to the extent that it comes down to argument down in due course, okay? Clear notices and correspondence to that effect. Now, if you are then assessing quantum, as I've said before, it has to be logical and it has to be reasonable, and your calculations have to be clear and they have to be relative to the contract documents. So you had a tender sum, which became the contract sum. You try and relate everything to it and always try and give a clear indication of cost to complete when it comes to quantum evidence and calculation. And always adopt a commercially reasonable position, not an unreasonable one. Now, what I find in my experience is that more often than not, all the parties, the contractors, the consultants, and the employers are on a stampede chasing a date. And people incur costs that they recognize that they're incurring costs, but they have not bothered to record it, they've not bothered to notify it, and they're only being reported and reflected historically after the event. If you give notices in advance, it helps you no end in trying to resolve the matter when it eventually comes to fruition. Okay, now what commonly fails? Now, weak claims often involve poor record keeping, emotional or aggressive submissions that have, if you like, no basis in fact and not supported by any evidence or contemporaneous record. You have missing notices, so you are due to serve notices, of various events during the course of the construction project, but you have failed to serve those notices, but you're realizing after the event to do so. Now, you take inconsistent positions. On the one hand, you record that a delay has happened, say, occasioning, let's say, 10 weeks of delay. But in fact, when one follows the chronology of your evidence, no more than 2 weeks can be established. It may well be that the balance of it is matters that are caused by you as the contractor rather than matters outside of your control, which would otherwise entitle you to an extension of time. And that position will be an inconsistent one. Or you have valued work items in an inflated manner rather than a consistent, contractually supported manner. Your evidence is late rather than on time, and you are then dealing and relying on poorly drafted contracts. Now, more often than not, if you are used to dealing with standard JCT contracts, they are properly drafted contracts. But again, users of JCT contracts often, more often than they should be, seek to amend clauses of the contract, and the difficulties that tend to arise in circumstances where you have amended those clauses and you've amended them rather too aggressively or otherwise wrongly. And if you are engaged in the conduct of seeking to amend standard contracts, you ought to be conscious of the concept of contra preferentum. And that is to say that when you have attempted to draft or amend a clause, any inconsistencies that arise as a result of that drafting or amendment will be construed against the drafter. So if it is that you've drafted it, then when it goes wrong, the presumption will be that it should be read against you, and the other side will be given the benefit of the doubt in those circumstances. So take care. If you're seeking to amend those standard terms, it will be advisable that you have them professionally drafted or amended. So disorganized document bundles. If you are disorganized in the documentation you submit in the course of your adjudication, then the adjudicator could be forgiven for not being able to cope with and follow your line of argument. And it would not be surprising, therefore, that if the opposition are better organized, then their cases are better understood, more easily understood, such that the adjudicator is likely to favor them rather than yours. Not for the mere fact that they have an organized bundle, but if they're telling a consistent chronologically sustainable storyline, and they have documentation to back it up. Unfortunately, with yours so disorganized, it would have been a case that you have a good story to tell, but you've ended up telling it badly. And what a shame it would be if, in fact, you have a good story to tell, but end up telling it badly. So specifically, let's concentrate for a couple of minutes on payment disputes. When you have payment disputes, which still remains a predominant proportion of construction adjudications, you may have encountered smash and grab adjudications. Now, smash and grab adjudications, it's my assumption that you probably will have an idea of the concept of smash and grab, and that is to say, matters have fallen due, notices have been served, and you haven't done what you're supposed to do when you're supposed to do it, and therefore, if the contractor, for example, has issued a payment notice and you, the employer, have not issued a pay less notice and the valuation has not been done, which is a payment notice in the intervening period, then by default, the payment application made by the contractor becomes the amount payable, and they start an adjudication on that. More often than not, they will be successful. So consider if you're issuing payment notices, whether they're valid or invalid, there usually are contractual dates and times and durations within which those payment notices will be issued, or indeed the pay less notices. And if those are out of sync, out of time, out of date, the likelihood that they will become invalid And if they are invalid, unfortunately, your attempt to rely on them will be unsuccessful. Now, with respect to interim valuation disputes, it's important to keep to the date that has been provided within the contract, and then to ensure that you maintain it consistently and try not to drop out of it, because there's been cases where interim valuations are out of sync, and therefore, question arises, should the employer be considering an interim valuation application that is not within the contractual date range? Answer, no, the employer is not obliged to do so. But if the contract provides that failure for that, the obligation is otherwise reversed on the employer to issue a payment notice, then the employer will carry that responsibility. Then final account disputes, of course, is often where everything comes out in the wash. So we've raced to the contractual completion date, and we have not maintained a clear record of what we're spending. And it is after we've come to the end of the contract, we found out that we've spent 10% or 20% more than we had budgeted for. And the claims then begin. And then notices that should have been issued in due time are now being issued out of time. And that leads to a significant amount of difficulties. So the key point here, now, many payment disputes are won or lost before even the adjudication begins. So consider, in the course of your contract administration, make the assumption that you ought to, the parties, the contractor and the employer, should be working in lockstep with respect to ensuring that we can visualize the final account. And the encouragement is here at with every interim payment to give an indication of a cost to complete, so that it is clear by way of notice to the employer where the contractor sees the cost going. And if an employer or a team of consultants with the QS and the like, saying that the contractor's estimate of the cost to complete is out of range, that is the time to almost call a halt, sit down and say, why are these costs going out of hand, and try and bring them back and identify at the earliest possible opportunity where the misunderstanding is and begin to resolve it then. Then matters could be resolved by discussion, negotiation, or change of tack, rather than waiting and ignoring the reporting until after practical completion, and then we're in a final account dispute. For a start, that is disadvantageous to the contractor because you've completed the work, you're offside. It's a headache for the employer because the matter is then heading to dispute resolution. Far better, I say, during the course of construction to put in the energy in order to ensure, pretty much as I tend to put it to many of my clients, it's a stitch in time that always saves 9 down the line. Okay, right. So if we looked at delay and extension of time claims, what adjudicators look for in delay and extension of time claims is not only do you have to have a construction program that is agreed, you have to have a construction program with a clear analysis of the critical path. The critical path represents the line of activities through the construction program in which you have zero float. Zero float equals to no time to waste, i.e. time is of the essence. Clearly, construction activities by their very nature are built one on top of the other. You couldn't start doing the external walls of any building without first having done the foundations. And if you have a delay in the ground in getting the foundations done, quite clearly, all subsequent activities are delayed. So you have to track your critical path from A to Z so that it is clear and which work activities that are beyond compromise. You cannot compromise any time lost in them. And if anything should impact them, then you're warning at the earliest possible opportunity of the impact ultimately on the final completion date. So there has to be a construction program with a proper program analysis, identifying the critical path and being mindful that anything that touches upon the critical path will have to be flagged immediately as a delay item, and appropriate notices served with proper site records maintained. Now, I put down causation. Now, often one looks for cause and effect. So what is it that we say that has caused the delay, and what is the effect of that? It may well be that a work activity is delayed by a week or two, but if it doesn't sound on the critical path, it can be absorbed and it doesn't lead to the delay in the completion date, and therefore does not entitle you to an extension of time. It isn't every delay that entitles you to an extension of time with the associated loss and expense that comes with it. So it is mindful. You have to be mindful to maintain appropriate records, being clear in your mind if delays are arising, what it is impacting. So weak delay claims often collapse because the parties cannot prove actual impact. You have to be able to say, not just that a delay happened, but what is the impact of this delay on my critical path, and therefore, how has it impacted my completion date? So that is very important with respect to delay analysis. Variations and valuations, common battlegrounds. Now, there is what I describe as the concept of scope creep. So a work item is described, but not fully. Construction begins, there is a requirement to do more. The scope of what is intended is increasing. Now, are you receiving appropriate instructions to cover that? You may be, but those may be verbal instructions. If there are verbal instructions, confirm the verbal instructions in writing, maintain a record of it, quite simply because being human beings, when we give verbal instructions, the human memory is not as retentive as it ought to be. Worse still, if those verbal instructions are the causes of a cost increase at the end of the day. Because if there's been a cost increase that emanated from a verbal instruction, the question is who has responsibility. Clearly, when there's an extra expense to be paid, the contractor wants to be recompensed for it. The employer is reluctant to pay for it. And if there is a record as to the origin of the instruction, then that makes it much easier to be able to resolve those issues. Now, you receive drawings, and it wouldn't be the first time for your works, but those drawings are incomplete. Now, if those drawings are incomplete, are you wide awake to the fact that they're incomplete, or do you actually wait until you get to the work phase and then you realize that when you have all the men there, but then the drawing information is incomplete? So much time spent in analyzing the quality of information that is being issued by the architect and all of the design team is very, very, very important. Those who have responsibility to issue drawings must satisfy themselves that they're issuing complete and credible drawings and information that the contractor can build to. And the contractor who is in receipt of this drawing should be able to analyze them in reasonable time, to go back and say, look, I've received these drawings, I'm rather expecting that many more, and include your request for these drawings in writing and maintain a record of when the drawings that you're seeking were actually issued to you, or when revisions are issued to amplify that which has already been issued. Now, if there are rates, as I say always, try and base it on contractual rates. If there are not contractual rates that can be relied upon, then try and agree the rates to be applied for each quantum of work at the earliest possible opportunity. Now, mainly to architects, contract administrators, and quantity surveyors, when you receive a contractor's rate, which often is bound to happen during the course of an interim valuation, do not just dismiss it out of hand and use a rate with which you're comfortable. Challenge it. Make it clear to the contractor that you're not accepting those rates, and then be able to justify the rates that you are advancing. And ultimately, when issues of contra charges arise, they become very contentious because the contractor literally turns up on the construction site with a view to getting paid for the efforts that he's going to make in building the building. He does not expect to be contra charged. But at the same token, it doesn't mean that a contractor that mismanages the contract should not be contra charged. They probably ought to be contra charged, and they should be given adequate notice of the contra charges that are coming their way. So the party with the better paper trail usually controls and dictates the outcome. Now, it does not mean that you should put all the emphasis in maintaining the paper records and fail to do the construction work on site. It is the ability to be able to do both. Maintain adequate records. It assists you, if you're the contractor, it assists you that much more if you're the employer's agent or any other consultants representing the employer, because as you will appreciate, when the consultants get it wrong, it is the employer that pays. When the contractor gets it wrong, it is the contractor that pays. So it assists both sides if adequate records are being maintained. So now I said, I mentioned the issue of credibility at the outset. Credibility matters no end. The adjudicators notices when one side is exaggerating, when one side is failing to give adequate explanation for specific activities or issues that are being relied upon, and you're being evasive. That is ill-advised to be evasive. When you're making unrealistic claims, when you're making a leap in logic in order to try and exaggerate the size of either the quantum you're seeking, or indeed in quantum in monetary terms, or in fact in delay terms that you're seeking. And when you're adopting an aggressive tactics, it's often not a zero-sum game. Don't always expect to win all and let the other side lose all. Give and take, where necessary, not always, generally does help. And the adjudicator will notice when you are adopting a reasonable approach. So a commercially sensible position is often more persuasive than an extreme one. So you can claim everything, but then it is always never, ever black and white. You can't always be right and the other side is wrong. Admit where is your shortcoming, where you have failed, but then explain that to the extent that the shortcoming is on your side, it didn't impact the bottom line as much as the other side are indicating, but then point out where you say that the necessity has arisen to justify the claim that you're making if you're the claimant or the referring party as distinct from the responding party, and of course, vice versa. Now, what happens after the decision? Possible outcomes. Once the adjudicator has made his decision, he becomes, as I said, functus officio. He's done his job. He's out of the picture. The losing party may just say, okay, enough is enough. I've fought the battle. Here is the payment. If that happens, fantastic. That is the end of the matter. You can move on. Now, often, the disgruntled, displeased party refuses to pay sometimes and decides to challenge the adjudicator's decision. Now, that may lead to enforcement proceedings where non-payment is happening and there is actually no challenge to the adjudicator's decision before we get to the issue of settlement. So an adjudication decision is often the beginning of often the commercial leverage, assuming that both parties are still on site. Not necessarily the end of the dispute. It ought to be the end of the dispute, because I'm sure you will appreciate the general philosophy of adjudication is pay now, argue later. But in certain circumstances, and I have advised in many of these circumstances where it may not be justifiable to make that payment, because if it were that you made the payment and the recipient will immediately dissolve into insolvency, and you believe that there is a flaw in the decision with respect to, say, the adjudicator's jurisdiction or the breach of the rules of natural justice, then you will be perfectly within your rights to, as it were, decline to obey that adjudicator's decision and to commence a formal challenge to it, and then put the matter beyond, as it were, the adjudicator and put it before the courts for determination. Is often an uphill battle, but is one that we have won once or twice as is necessary in order to make progress in the matter. So that's what happens after the adjudicator's decision is made. Okay, so avoiding adjudication problems generally, you can do so before they start. The best dispute resolution strategy, in my view, is always prevention, is always better than curing it if you can prevent it. So better contract documentation, and if you are going to engage in the course of amending standard forms of contract, or indeed drafting bespoke contracts, you cannot but have them professionally done so that you actually are protected. And once those contract documents are in place, better contract administration, in other words, adequate record keeping. Now, if you have to serve notices during the course of a construction contract, ensure that they are timely and they are proper. And then, as I keep harping on, maintain your records cleanly and consistently and adequately, and where necessary, seek the earliest possible legal advice, not the latest possible legal advice. More often than not, I'm consulted when it has all gone wrong, and one is then engaged heavily in trying to retrieve as much as is possible. Best to seek the earliest possible advice so that you can actually strategize for what you're heading into, and therefore be in a better position to deal with the disputes when they actually do arise, because they do arise. So key takeaways, therefore. Construction disputes are usually decided by preparation. So if you're going to start a construction contract, best always to have it in your mind that is likely to go wrong, and therefore prepare for it. It doesn't mean that you're stalking the other side every inch of the way, but you are capturing the essence of what you're doing. Excuse me, recording when things deviate from that which was agreed, maintaining appropriate documentation, being mindful that time is always of the essence, notwithstanding that time does not become of the essence until it is made of the essence. But if you approach construction contracts with your antenna up, noting that there has to be a start and a finish date, and that if there is any deviation in the completion date, it usually leads to a debate or an argument or a dispute, then ensure that if that date is going to be missed, that you are not the party causing it, that if anything, you are the party maintaining the records to explain how we got there, and therefore help in resolving any issues that arise throughout the process. Maintain credibility. Do not make assertions that you cannot back up with the sheer evidence of what has happened, and maintain commercial realism. The strongest projects are not the ones without problems. In fact, the best projects are the ones where the project managers and contract managers have consciously prepared to deal with unexpected eventualities that will happen from time to time. Okay, so by way of summary, therefore, these are the key takeaways that you take from this webinar with respect to adjudicators' decisions. So we're going to then move into questions and answers. To the extent that you have any, it'd be my pleasure to take them and address them. Now, specifically in this webinar, I've given you an overview, not dive down into the details. We have opportunities to go down into details in due course to the extent that that is deemed necessary. So I can now open up for questions and answers, and fire your questions if you have any, and I will endeavor as much as possible to give you the clearest possible answers to them. And thank you very much for listening.
So everyone now can unmute themselves or put a question in the chat if they like. So we'll start with the questions that are in the chat. So Samuel, Gavin Peabody's asked, does that mean a technically correct claim can still fail because of how it's presented?
Oh, yes. Oh, yes. That is as clear as night follows day. A technically sound claim, a very viable claim. As I did say, my expression always is having a good story, but telling it badly. If you have a good claim, but you can present it well, I'm afraid you lose, which is disappointing. And it is always advisable to appreciate the limit of one's own ability to present the case, and ensure that you get good guidance and as to when it is within your capacity to present your case well, and when you otherwise might seek better guidance and support in order to be able to present that case. Yes. So that's the answer to the question.
Fantastic. Any more questions in the chat? Okay, Gavin said, so what's the best thing to do after getting a favorable decision?
After getting a favorable decision, it's usually the case that a good adjudicator's decision will state in it the period within which the party that has been ordered to make the payment, to make that payment. And you want to very quickly write to that party to confirm that they will in fact be making the payment as ordered. Now, if the payment does not materialize after the due date, then you will send them a reminder that the payment has not materialized, and unless they can confirm that that will be forthcoming, you'll be left no option but to then start taking enforcement proceedings. And unless you get an answer indicating that there is an intention to challenge the adjudicator's decision for one reason or another, then it will be my advice that if payment date as ordered by the adjudicator has not been made, that you be entirely justified in commencing enforcement proceedings. And I assume that you'll be familiar with enforcement proceedings, or otherwise that's a matter that one can advise on. You usually apply to the courts and get summary judgment, which is enforced in the usual way.
As you were answering that, he did ask, how long does enforcement take and what does it cost?
Okay, now it's interesting. The cost is obviously variable. How long does it take? An application to the TCC, Technology and Construction Court, for enforcement is usually rapid. The courts are alive to the necessity for swift enforcement of adjudicator's decision. And once an application is made, it goes very quickly indeed. It's not a matter of months, it's a matter of days and weeks, and it happens. It depends, of course, if the responding, or if the party that's been ordered to make the payment is going to resist it. Because once notices of commencement of enforcement proceedings have been received, they then will, through their lawyers, click into action to try to resist it. And it then follows as to whether or not the enforcement is going by way of Part 8 proceedings or Part 7 proceedings. And what do I mean by that? Technically, it's whether the matter is going to be disputed and therefore fall into an argument. But if it is not going to be disputed and doesn't fall into an argument, it just goes through rather rapidly through the courts.
Okay, fantastic. If anyone else has a question, please do free to put it in the chat or unmute yourself. You can
Or unmute yourself and ask it. Now, interesting, I'm content to keep answering the questions as long as they are coming. And once again, it'd be appropriate to acknowledge the technical difficulties we had at the beginning of this webinar, which may have affected your participation or enjoyment of it at the outset. We're, of course, sorry that there were those technical issues, but it seemed to be beyond our control. And hopefully, we will get to the bottom of it subsequently.
Okay, I think Gavin's got one more question asking what the most important document is. Is it the contract?
Without the contract documents, first and foremost, for you to be able to adjudicate at all, you have to prove the existence of a construction contract. So the contract document is key and number one. It is only when the contract is established that you can then point to which clauses of the contract that you allege have been breached and how. So the most important document, always, you exhibit the contract. Indeed, if you can't prove the existence of a construction contract, you're not within the umbrella of adjudication, and therefore any decisions made without a construction contract is null and void and unenforceable. Okay.
Okay, he said thanks, so he's acknowledged
Okay.
your answers there. Unless Does anyone else have any questions? Do feel free. Don't be shy. You can put one in the chat. Okay, we've got another question. How do you approach issues where the client has entered into the contract in bad faith and does not want to pay?
Well, that is loaded. That is very much loaded. It will be actually terrible for any employer to enter a contract in bad faith. A contract is usually a clear means of distributing responsibilities, obligations for the delivery of the project. And a contract, a client will always accept that he has an obligation, or an employer would always accept that they have an obligation to make payment for the work that the contractor has been, as it were, authorized under the contract to execute. It is unimaginable that an employer will totally refuse to make payment, but some employers may adopt the approach of wanting to challenge every payment because there is a contract sum, or there is an agreement under a letter of intent to reimburse the contractor for the cost that they incur in the course of delivering the project. So the employer would always start, I would like to think, with, if you like, a clear intention to pay. I think where the issues tend to arise is where the contractor believes, say, for example, that they should be paid £1,000, and the employer is of the view that they should be paid £800, and the dispute is often on the difference between what the contractor is claiming and what the employer is willing to pay, and that difference is the issue. Now, bad faith is significant because that will completely vitiate the contract, and I think that is loaded to say that the contractor has entered the contract in total bad faith. That would be quite disastrous for the employer from my point of view. No, so how do you approach the issues? You make your claim, and any employer that enters into a contract in bad faith will very quickly be found out, because interim payment number one, they have to make it unless they can say that what is being claimed is proportionately higher than the value of the works delivered on site. Then one can have a debate on the difference, on the variance between one view expressed by the employer and another view expressed by the contractor. And that usually a foretaste as to how matters are likely to pan out. And the contractor will then be well advised to seek the earliest possible opportunity to sit down and say, why are we a million miles apart on day one? Because that can only get worse down the line. So how you address it is by following the terms and conditions of the contract, and the employer would always be held liable to make payments that they're supposed to make.
Well, the follow-up to that is, I have had a client in a contract worth hundreds of thousands who had a change of director and just decided that they preferred not to pay and tried to get me to conspire with them, and I refused.
You're well advised to have refused indeed. Quite clearly, the change of directors within an employer's company has absolutely nothing to do with the execution of the contract as intended. The obligations entered into by the prior directors will bind the new directors, unless, of course, they want to serve notices to terminate the contract. They cannot, just because of a change of directors, prefer not to pay. They should be compelled to pay, and they will indeed be held liable to make those payments in adjudication and subsequently by a reasonably competent court of law. I hope that is, if you like, a fair enough indication. It is always good to ensure that you're playing with a straight bat in those circumstances.
All right, for any commenters just wondering, you can get the slides by email, so everyone will get a follow-up with the slides and the recording.
Okay.
Collins asked, historically, I've always felt the main contractor held the cards and subcontractors, especially smaller ones, resisted making bona fide claims as they would get steamrolled. Do you think this is more balanced now in the UK?
Well, the whole idea of adjudication was always to ensure that the smaller subcontractors are not held to ransom by the bigger main contractor. The nature of adjudication is that there is a balance because subcontractors, however small, what matters is that if you have a bona fide claim, you should make it. Now, it may well be that a contractor who is giving you lots of work is saying that, look, don't make that claim because I won't award you the next contract. Inappropriate as that may sound, that is not justification for you to let go an entitlement that you have now. Claims consciousness is to be discouraged, but that is not a substitute for failing to get proper recompense for extra expense to which you've been put in the course of a contract by, if you like, proper instruction. So there is, if there are bona fide claims to make them. Hopefully you won't get steamrolled, as it were. There is a fairer balance to my mind, and often I get consulted by smaller trade contractors as well as the big main contractors and the employers. And I do not take the view that the smaller subcontractor, by dint of being little, should be ignored. That is not appropriate. The smaller trade contractors are actually the lifeblood of the construction industry and ought properly to be looked after, because they are the people at the sharp end, and they are the people at the work face, ensuring that the main contractors are able to deliver their primary obligations. So I think there is a fairer balance. But clearly, get yourself on adequate advice on time. It goes without saying that the bigger main contractors are likely to call upon the likes of me earlier than the smaller ones. But it's not that much different, that the smaller subcontractors should be just as protected. Okay.
Okay, we have a career question from LB who asks, can you become an adjudicator within a legal firm, I think a law firm, if you study an adjudication legal course without holding an LLB?
Well, that's interesting. Anyone in the construction industry can become an adjudicator. I know lots of adjudicators who are quantity surveyors or architects or engineers. You don't necessarily have to be a lawyer to become an adjudicator, but suffice it to say that you are engaged in legal proceedings, really, and therefore you'd better be technically sound on the law. The issue arises when you are not legally trained and you're sitting as an adjudicator and you have competing parties who are lawyered up to the hilt. And the likelihood is that you may well actually find yourself as the referee at a disadvantage, because there are hard-hitting lawyers on both sides. But mind you, it is accepted that an adjudicator may not necessarily be a lawyer. So where I have participated in adjudications where the adjudicator is not a lawyer, I've taken the view that one will assist the adjudicator as much as possible with pointing them to the relevant legal precedent to rely on, as well as assisting with interpretation of that where necessary. And hopefully both parties can assist. Yes, so you can become an adjudicator. I'm not quite sure that you can do so within a legal firm. You don't have to be part of a legal firm to be an adjudicator. You simply have to be competent and then be able to apply to and become accepted by one of the adjudicator nominating bodies, such as the Royal Institution of Chartered Surveyors, the Technology and Construction Bar, which you can't because you're not a barrister, or TEXA, Technology and Construction Solicitors Association, which you can't because you're not a solicitor. So if you're an engineer, your royal institution, as the case may be, will have their own body of their professionals who are trained and can become adjudicators. So that would be your quickest route. Okay.
Are there any other questions?
More questions are welcome, and if they're not, then it'll be a pleasure to wrap up for the evening and express our gratitude for your attendance, and hopefully look forward to seeing you in our next adjudication, notice of which will come out in the usual way. By the way, you can make contact with us by scanning the QR code on the screen, or by telephone or email to our clerking team. And any questions that may arise subsequently that you may not have thought of now, you feel free to post those, and we will try and assist as much as possible. And of course, if you need to, you can catch up on our parts 1, 2, 3 of the construction adjudication series before we got to part 4. So I thank you very much, and I suspect we can come to a close now.
Yep.
Okay, thank you very much. Bye-bye now.